Today we are discussing lease, and as I said, mortgage and lease are where limited transfer of interest is made to the transferee. Lease, the provisions of lease are governed by sections 105 to 117, and as my copyright goes, I will again prove that each and every provision related to lease is logical and a clear-cut common sense approach. And therefore, if even if there is no such provision, it is the parties, if there is a lessor or a lessee or even a transferee of the lessor, the provisions are very logical in its approach. Now, lease, definition of lease is under section 105 of the Transfer of Property Act, and therefore what is ultimately a lease? A lease of an immovable property is a transfer of a right to enjoy property. That's very important. What it is a right to enjoy such property for a certain time period. Now that time period can be expressed or implied. But what is important is there has to be a certain time period for enjoyment of the property. If a lease is created, then importantly, there has to be a duration of lease. Duration of lease subject to parties having a understanding which is reflected in the deed of lease is defined under section 106. Then naturally when there is a lessor, the lessor is the one who is the one who creates the lease, and the lessee is the one who gets the benefit of the right to enjoy the property. The money paid under the lease deed is premium, and whatever is paid for even as a share of crop or money in every duration, that is called rent. Now once there is has to be a duration and there has to be enjoyment, then naturally there would be rights and liabilities. Rights and liabilities of lessor and lessee are explained in section 108. And once I come to section 108, it is absolutely logical and common sense which the legislature has just put in and documented in the law books. It is also important to understand how lease is made. Now, whether it is under a registered document, whether it can be oral. So that is explained under section 107. So now when we come to definition, it's already explained in section 105 that a lease of immovable property is a transfer of a right to enjoy such immovable property for a certain time or in perpetuity for a consideration. Consideration is most important because that's the basic rule of contract. No consideration, no contract. So there is this consideration which is twofold. One is a premium and another is rent. Now, when you come to section 106, that is duration. The duration depends upon the type of lease which is created. 106, when it is relating to a manufacturing process or when it is for agricultural purposes, it is deemed to be a lease from year to year, and it is terminable by a notice period which is of 6 months. Now, all this, whenever I express or point out the law, one has to appreciate that it is all subject to anything which is contained in the contract or on local usage or law. Manufacturing or agricultural purpose is deemed to be a lease for year to year, terminable with a notice of 6 months. Any other lease is deemed to be a lease from month to month, and that is terminable either by the lessor or lessee by 15 days notice. Right? Now, one thing which has to be appreciated, that if in the contract uh, there is no mention in a month-to-month lease that a lease, which I'll explain to you subsequently the provision, then the right to terminate is with the lessee only. Lessor cannot terminate. That I will explain to you subsequently. But what is important is this deeming provision and termination, how the termination has to take place. Now, termination, again, notice which is mentioned, there are judgments on whether a notice is compulsory, mandatory, or not. I will explain to you that too. But what is important under provision of section 106 is that such a notice has to be in writing, has to be signed by the person who is delivering it, and it has to be delivered to the lessee personally or to one of his family members or to his servants at his residence. This is the necessity of the requirement of notices, because as it is, a lease is only for enjoyment for certain period, and it is always terminable. If terminable, notice becomes very important. However, there is a distinction which is created between a tenant holding over and tenant at sufferance. That difference I will explain at my in my later part of my presentation. But it's very important to understand that there is a concept in India, and that concept is only available in India. It's not in England. That there is a distinction drawn up between a tenant holding over and a tenant at sufferance. So when we look at 106, that's relating to the term of a lease as well as the notice period for terminating it. Now we come to section 107, which is again logical, because ultimately the very purpose of Transfer of Property Act is persons to have notice of any transaction that takes place, to avoid multiple difficulties due to multiple transfers taking place without knowledge. Certain provisions are put up to protect transferees without notice. Innocent people need to be protected. So all these provisions are part of the Transfer of Property Act. And that is that when there is a lease for a term of 1 year or more, such a lease can only be made by a registered deed. And if it is other than that, it can be either by registered deed or by oral agreement or by settlement. So law provides compulsory registration. And there is also a presumption that if a particular document, that is the deed of lease, is required to be in law under 107 to be a registered document, and if it is not registered, then the presumption which the law itself provides is that it would be for a duration of section 106. That is for manufacturing and agricultural purposes from year to year, and for other leases month to month. So there is a presumption, and that has been reiterated by the Honorable Supreme Court in Alambur Engineer versus Ramkrishna Dalmia judgment. Now, many times question arises where even if there is a document, this deed of lease which is required to be registered, is not registered, then what are the consequences? Now, those consequences are under section 49 and 47 of the Indian Registration Act. Section 106 provides for a presumption. So there can be document which is required to be registered. If not registered, there would be a presumption. If there is an admission that person is a lessee, he admits that he is in possession as a lessee, then there is a presumption. Now that presumption then would not be in accordance with what the agreement is. Now the document may be that it would be for a 5-year lease or a 9-year lease. But in the absence of the document being registered, it would be presumed that it is for a period of 1 year. So registration therefore is important if the parties want to rely upon document. Otherwise, no part of that document would be permitted to be relied upon in evidence. That is how section 106 and 107 proceed on. Now, when there is a lessor and a lessee, definitely there has to be rights and liabilities of both lessor and lessee. And that is under section 108 of the Transfer of Property Act. And again, absolutely logical. Parties have to enter into a lease. Definitely the lessee, the first question he will ask is, are you entitled to this property? Is there any defect that is in your property? Or he will take a search and find any such adversity or any difficulty in the title, or for the purpose for which it is to be used, is there any problem in that? But the law itself also provides that the lessor, as in the case of when he is selling the property, he is bound to disclose to the lessee any material defect in the property. That's very important because the lessee ultimately has to use it for his enjoyment. So there cannot be any proper use of that property made by the lessee if there is somebody else who is claiming a title or there is a material defect or a problem in that title. So the lessor duty is to explain to the lessee what is that material defect or any problem in the title or for the use of that property. Now this is subject to also that which the lessee cannot by ordinary care discover. So he has to make his own inquiries, and as a prudent person or as a normal man, if somebody would have become aware, then he is bound by that because he would be negligent otherwise. So lessee has to do his duty. Also, reasonable care has to be made, and every inquiry should be made to find out any defect. But if certain defects are only known to the lessor is bound to disclose that. Then naturally the lease is taken because lessee wants a right to enjoy the immovable property. The lessor has to put the lessee in possession. Once the lessee requests that he should be put in possession, the lessor has the duty to do that. Then again, the contract, to maintain the sanctity of contract, there will be an understanding, or that is a by law provided, that if the lessee pays the rent and performs the entire contract, then lessee would hold that property and enjoy the property without interruption from the lessor or by any person claiming through him. Now that's a basic requirement, because if somebody is taking a property for enjoyment, then naturally if he performs his part of the contract, there should not be any interruption for him to enjoy the property. Again, very logical. Every person would expect that. It's not necessary that law has to provide. It's but natural that whoever wants to enter into a contract would like to enjoy the benefits of that contract. So this is how, even for a lessor and lessee, the rights and obligations go. And this, as I pointed out, are important rights. So it runs with the contract. Okay. And it would be for the benefit of every person to whom the interest is vested. So even if ultimately the lessee creates a sublease, naturally, if the contract provides that there has to be permission of the lessor, then that permission has to be taken. But if he creates a sublease, even the sublessee would be entitled to the benefits of these rights as it runs with the contract. Now, this is as far as the lessor is concerned. Now, the next part is the rights and liabilities of the lessee. And those are, naturally, he is enjoying the property. It is for his benefit. So there are many. As far as lessor is concerned, there are only three, as can be seen. But as far as the lessee is concerned, there are many. Now, the first is right to exception. Again, very logical that if you are taking possession of the property with a right to enjoy that, then you have a right to accession. But that is subject to law relating to alluvium. Now, again, in this provisions also, legislature has put certain words which are helpful for lawyers to have some advantage over laymen. So now alluvium, law relating to alluvium means any provisions under the other statutes which applies to an increase of land due to actions of water, whether natural or by artificial cases. So if there is any land which is relating to next to any water body, and due to natural or artificial causes, if there is an increase in the land, then benefit of accession to the lessee of that land will be subject to the law relating to that. So whether reclamation permitted, not permitted, all that aspects will be taken into account, or CRZ rules will be taken into account for this right of accession to be enjoyed by the lessee. Now the other is, if due to any natural causes, or if by any rights or any such actions of people, any property is destroyed, or it cannot thereafter be used or utilized by the lessee for the purpose for which it is leased to him. Like if it is for manufacturing purposes, it thereafter cannot be used as a plant or as a factory. Or if it is for agricultural purposes, it cannot be utilized for growing crops. Then, in such an eventuality, at the option of the lessee, again, this option is only given to the lessee, that he can declare the lease as void. So, if it is for the lessee to decide in such an eventuality whether he can utilize it or not. And one other which is logical is the lessor gives some property and he is bound to make any repairs or to maintain the property. And if he fails to do that, then lessee can carry out that repairs. Okay. And then whatever the expenses he has incurred, he can recover it from the lessor. Other is again very logical that if some payments have to be made by the lessor, and if he doesn't do that, the lessee may make such payment and make good it that payment from the rent, and also recover whatever interest he would have incurred for making that payment. Now, one other aspect which is very important is that when a lease is created and some constructions are made, certain machinery is attached to the earth. Now, in such a case, even if under 111 there is a determination of lease, or lease comes to an end for whatever reason, then the lessee has a right, when only whilst he is in possession. So this is very crucial. Whilst he is in possession, he has the right to remove all things that is attached to the earth, and attached to the earth not by the lessor, what he has attached to the earth during the continuance of the lease. And crucially, he has to have the property at the same state in which he acquired it. He can't destroy the worth of the property. So this is certain things which balances both the lessor as well as the lessee's rights and interests. When you take, especially even long-term leases, then certain constructions are made. People spend on that. So if that is removable without creating any damage to the land, the lessee, while he is in possession, he can do so. Now the sixth one is when there is an agricultural lease and it is not for a fixed period, the duration is uncertain. And if the lessor determines or the lease gets determined, except where it is due to the fault of the lessee, then the lessee is entitled to all the crops, and to collect those crops or to cut those crops, he also has a free entry and exit from that land. Other is, even a lessee would have a right to transfer his leasehold rights or mortgage it or sublease it. This is another right, but this is all, as I said, subject to contract to the contrary. And corollary to the material defect which the lessor has to convey, the lessee also is bound similarly to the lessor to point out the extent of interest or benefit which the lessee can make, which he is aware and the lessor for some reason is not aware. Then lessee has to pay, there is a statutory duty on him to pay the premium and the rent at the proper time and proper place. Then he has to maintain the property, and on termination, he has to give it back in good condition. Similarly, if the lessee becomes aware that there is any legal proceeding which may affect the lessor's right, he has to immediately bring it to the notice of the lessor. He has to take care of the land as if it is his own. Then he cannot, without permission of the lessor, erect any permanent structure. And naturally, when the lease comes to an end, he has to give back the possession to the lessor. Again, at the cost of repetition, I would like to say all this, if you see the 14, whatever the duties, the rights, liabilities of the lessees, it's all very logical, extremely common sense. So even if part of the contract or not, parties would naturally think that this would how, when the transaction of lease is, this is how they have to proceed with respect to each other. Now, that is as far as the rights and liabilities of lessor and lessee. Now, in certain cases, there is a transfer. There is a transfer of lease, lease property. Then what happens? That also, looking at section 109, reading it once, twice, you feel, why is it so, difficult? People think it is difficult, but when you read it, you realize it is very logical and very simple. Now, what the legislature has tried to create a distinction is that if the lessor transfers the property that is leased to somebody else, then though the rights passes on to the transferee, the liabilities do not automatically pass on. The liabilities pass on only when the lessee elects to do so. So it depends upon the lessee. It's a right given to him to elect whether he would want the liabilities to be burden on the lessor, or he is willing that from now on the transferee can take the burden of the liabilities. So that right has been given to the lessee. It doesn't automatically get transferred. Also, very importantly, about the arrears of rent, the transferee is not entitled to arrears of rent prior to the transfer. It belongs to the lessor. And even subsequently, even if after the date of the transfer, if for reasons that the lessee is unaware of the transfer, and if he wants, he pays the rent to the original lessor, then he is not bound to pay back to the transferee. This again a protection which is provided to the lessee. Then if there is question as to how the premium and the rent and everything is to be shared, all that can be sorted out between the parties. And if they do not, then they have to go to court having jurisdiction, where as far as disputes relating to suits for possession, the court which has the jurisdiction will have to decide that part of the dispute between the parties. So again, very logical, try to create as much simplicity as possible, and importantly, therefore, very easy to understand. Now, question arises that there is a duration of lease. Now, how is that duration to be calculated? How is it? What date it commences? Many disputes arise on such aspects. Law has tried to clarify and made it very simple. So, if there is a provision in the contract which says that the lease commences from a particular day, then for calculating the term of the lease, that particular day has to be excluded, right? So if a day is mentioned that it would be commencing from, say, 1st of December 2020, then 1st of December has to be excluded. It starts from 2nd December, the timing, and then an anniversary, 1 year. If it's year to year, 1 year would be 1st December 2021. So anniversary is also very important. So if 1 year, then how anniversaries would be? Like one person has to remember if married, his marriage anniversary. If not, meeting his girlfriend, then he'll never forget what is an anniversary. So anniversary is something which is again not explained, but it is very much part of the duration of lease under section 110. And if no date of commencement is mentioned, then it is from the time of making of the lease. So this is absolutely important. Two differentiation, clear cut distinctions. And if it is year to year or if it is for a number of years, then as I explained, unless there is an express agreement to the contrary, the lease shall last during the whole anniversary of the day from which such time commences. Right? And then there is option to determine lease, and that lease is always terminable before its expiration. And if, as I earlier pointed out, if the lease deed omits to mention at whose option it is so terminable, then such an option is only available to the lessee and not to the lessor. Now, naturally, if there is a term of the lease and the lease deed provides for certain obligations and duties which each party has to perform, it has a certain period where the right of property has to be enjoyed, then naturally there would also be that one day the lease has to come to an end because it's a limited right that is transferred. So it has to come to an end one day, and that one day how it comes. So when there is a fixed tenure mentioned, it comes to an end when that fixed tenure expires. Now, if it is conditional, then the lease is determined on the happening of that event. Other is if the lessor power to dispose of the same, the property, is only to the happening of any event, then by happening of that event, because the lessor then loses his rights over the property itself. So one can only give what one has. Now, if he doesn't have, then he cannot give any right to a third party to enjoy. So therefore, the lease is automatically then determined. The other is merger of titles. On my last presentation, I explained merger. When the lessee and the lessor becomes the same person, then there is a merger which takes place, and therefore that lease comes to an end. One cannot be a lessee of oneself. So once there is a merger taken place, the lease has come to an end. The others is where the lessee surrenders expressly or impliedly. Again, the lease is determined. Then there is a question of forfeiture. Now, forfeiture are three conditions which are in G. One is if there is any express clause and that clause is breached, then there is a forfeiture which takes place. Then other is forfeiture which takes place is where he questions the title, lessee questions the title of the lessor. Again, that would be a forfeiture. Now, Similar provision, if you see, there is under section 116 of the Evidence Act, that there is a estoppel on the lessee questioning the title of the lessor when giving the lease. Many times, the in a dispute, the lessee questions the title of the lessor. That itself would result in forfeiture if wrongly taken. I'll explain further down when I would explain the principle of title by paramount holder. Those are certain principles of law which are not as far as mentioned in Transfer of Property Act, like tenant at sufferance is not mentioned, then title of paramount holder is not mentioned. But I will explain to you that subsequently, because those are very subtle but very important features in relation between a lessor and a lessee. So it would be my duty. I feel I would fail if I do not touch those subjects. So I will do that. But again, if the lessee questions the title of the lessor, that itself would result in forfeiture. Or if the lessee is adjudicated as an insolvent, that would again result in forfeiture, because this is something which is for the protection of the lessor. Because as you know, if it is somebody is declared as an insolvent, then a receiver or an authority is appointed, and therefore that property would otherwise go in their hands for benefit of the creditors, at least those rights. So therefore, in law, there is a provision that if a lessee is declared insolvent, that would be a determination of the lease by forfeiture. Then H is on the expiration of notice to determine the lease or to quit, or there is an intention to quit by the lessee. So in such a case also, there is a determination of lease. Now, if you see, as I said, there is a forfeiture. Now, if there is some right available, also there would be a right to waive that right which is accrued. So the landlord who has the benefit of forfeiture in his favor, he can accept the rent that would amount to waiving his right to enforce forfeiture. Or he does some act, he allows maybe the lessee to carry on his agricultural activities, that would also lead to a conclusion that he is treating the lease as subsisting. Now the question is that for that, first he has to understand that the forfeiture has been incurred, correct? So if the lessee has been declared insolvent, he has to understand that forfeiture has come into effect, or a material breach of a contract which has taken place, he has to understand that that material breach has occurred. Only then waiver comes into picture. Person not being aware, he cannot waive, because he first has to know that he has a right for him to waive that right. So only once he is aware that he can waive that right by his actions, express or implied. But the exception is that suppose if he has, on the basis of the forfeiture that takes place, already filed a suit for eviction, and thereafter if he accepts any rent from the lessee, then such an acceptance will not amount to waiver of forfeiture. That's an important factor which everybody has to appreciate. Now, if, as I pointed out, that there can be a lack of some material breach or rent not being paid or anything, there is a notice to quit. That also the landlord has a power, or it is within himself to waive that right that has accrued to him. If somebody has given a notice to quit, and if his actions then go to show that the other party is treating the lease as subsisting, then there is a waiver that takes place. Again, there is a right, and that right is given up. So logically, because legislature wants that parties do everything by their own will, and it's not that once they have taken a decision or some factor has come in which amounts to determination of a lease, then they are continued to be bound by it. They have a right. Ultimately, when parties enter into contract, it is for their mutual benefit, and they are comfortable with each other. So it doesn't mean that an action would lead to complete closure. They always have a right to go back on such. decision which they may have taken and restitute it back to the original position. Now, if there is a forfeiture which has taken place for non-payment of rent, is it absolutely fatal for the lessee? Being a beneficial state, that should not happen. It sometimes happens that people are not in a position to pay the rent as of today because of these circumstances. Statutorily, they may be protected, but sometimes people may be in difficulty and genuinely they would not be in a position to pay the rent. Then do they lose the right to the property immediately thereafter? Under 114, that's not the case. They still have an opportunity and they have to make use of that opportunity, because otherwise this would be very strictly construed. If you do not take advantage or take benefit of these provisions, then you will not be protected by the court. So if for non-payment of rent, if the lessor files a suit, then at the hearing of the suit, the lessee may pay it or he tenders to the lessor together with full interest, whatever is accrued, and also the cost of the suit. Or even if then he is not in a position to pay the rent, he gives a security to the court, which is sufficient for making such payment within 15 days. Then the court may, in his discretion, not make an order for ejectment, but relieve the lessee from forfeiture. And thereafter, he would again hold the property as if no forfeiture has taken place. But this 15 days and the payment is very important, because if you fail then the courts also would not be in a position to help you if it is proved that you have failed to make the payment of rent. So person who has incurred forfeiture because of non-payment of rent have to be very careful about payment being made in court at the hearing, or at least give security for to be paying it within 15 days. Now, in certain other cases where there is a material breach of a contract, and because of that there is a forfeiture, to avoid any fraud being played on the lessee and to protect the lessee's interest, there has to be a proper notice in writing which is to be given, and also to specify the particular breach. And in case where that breach is capable of being corrected, then the lessee should be given reasonable time for correcting the breach. Now, the important part is that such a breach should be capable of being remedied. And if it is so, the lessee would have some reasonable time to do so. So it is, as you can see from section 14, 14A, and also 112 and 113, that legislature intention is to save the lease, to save the contract, doesn't want it to easily terminate or lessor or lessee to part ways. Only when it is absolutely necessary, or it's absolutely both the parties agree, or it is something that lease has to be terminated or lease has to end, that the lease would end. Now, if you go further, again, this is very logical. Now, if a lessee who has created an under lease, if he surrenders or if there is a forfeiture, then whether the rights of the under leasee also gets affected, his rights also gets terminated? No, his rights do not get terminated. So under lease's rights, if it is there is a surrender by his lessor, either express or implied, the law provides that his rights do not get prejudiced unless the surrender is made for obtaining a new lease. And in cases where the intermediate lessee, the intermediate party, he surrenders, then that contract is binding on the under lessee for the rent what is payable, and that would be payable to and it will be enforceable by the lessor. But if there is a forfeiture, then it annuls or impacts all the other under lessees also. Again, that with the proviso, with the precondition that in such a case where there is a fraud which is played by the lessor, then that would not affect the under lessee. And whatever the provisions of section 114 are for protection against forfeiture, that again will be applicable or exercisable by the under lessee. Now, as I pointed out, a case where there is a paramount holder who is one who is most important than anything else. And who is more important in a lease? It is the lessor. Now, normally, when there is a lease and there is a lessor and a lessee and a sublessee, a sublessee is bound. A sublessee is bound to hand over possession when his lease is determined to his lessor. That is the lessee, because it is he who has created the lease. That is the lessee. But in certain cases, there can be an eviction by paramount holder, and that has been explained by the Honorable Supreme Court in Vasudev versus Balkishan. And he has stated, the Supreme Court, the Honorable judges have set out three conditions under which there can be an eviction by paramount holder. And that I have culled it out and put it in my PPT. Now, question arises is, what is the effect of holding over? Holding over means if there is an end of the lease, then even after the efflux of time, the lease is come to an end. Then when it is a tenant by month to month, then the landlord has allowed him to continue to be the tenant. And in such a case, if he accepts the rent without filing a suit for eviction, then the person becomes a tenant from month to month, and he is then known as a tenant holding over. Similarly, there is a concept of tenant at sufferance, which I pointed out, which has been part of recent Supreme Court decision, which was decided only on 19th March 2020. That is Nandram versus Jagdish Prasad, and it has referred to Delhi High Court judgment of 1999, and it points out that the person, the lessee whose lease has expired and whose continuance as such lessee is not assented to by the landlord, then such a person is tenant at sufferance. Though he doesn't become a trespasser as such immediately, which is the concept in English law, in India, he becomes a tenant at sufferance who can be vacated only by filing a suit. Filing a suit is necessary. He doesn't automatically become a trespasser. But the difference is that in case of a tenant holding over, you have to give him notice as required in law. If he is month to month, the 15 days notice is necessary. But if he is tenant at sufferance, then as decided by Honorable Supreme Court in 2019, which referring to many of the other Honorable Supreme Court decisions, both as to when notice is to be given and when notice is not to be given, the Honorable Supreme Court in Sivok Properties versus the West Bengal State Electricity Distribution Commission has said notice to quit is not necessary in case of tenant at sufferance. So, effect of holding over, which is section 116, which says that even after the lease is determined, if the lessor continues to accept rent, then the lease is deemed to be renewed from year to year or from month to month according to the purpose for which the property is leased. So if it is manufacturing or agricultural purpose, it is year to year. And if it is any other purpose, from month to month. Again, subject to agreement to the contrary. So the important aspect, the distinction between a tenant at holding over and tenant at sufferance. As pointed out, the concept of tenant at sufferance is only in India. The concept of tenant at sufferance is not a concept in English law. Now we go to the last section, which is an exception. It takes away the effect or impact of provisions of section 105 to 116, where it won't apply to leases for agricultural purposes, where except the state government by notification declare all such provisions to be so applicable. And it then says that such notification will not take effect until expiry of 6 months from date of publication. So 117 takes away the statutory effect of 105 to 116 on leases for agricultural purpose. Now, one other aspect which is very important as far as practice is concerned is distinction between a lease and a license. Lease is covered under sections 105 to 116 of the Transfer of Property Act. License is something which is covered under the Easements Act. And Easement Act is not part of any curriculum which the law colleges teach, as far as I am aware. So I thought that it would be better that if we have the distinction between a lease and license explained and specified in my PPT. Now, as pointed out in the definition of lease, there is a transfer of interest to enjoy the property. In case of license, it's only a permission. It is to the license specific that he can use it for a particular purpose. As far as lease is concerned, it is both heritable and transferable. No such right is available as far as license is concerned. It can be terminated as provided in section 111. Here it can be under the contract, it may be mentioned, and no reason is necessary to terminate a license. Issue of forfeiture also is there because there is a pleasure or just by evolution of the licensor or licensee, if it can be terminated, then question of forfeiture issues don't arise over there. But license, definitely there would be a mention that if there is a insolvency or if a person is unable to pay the license, then the license would be terminated. Licensee's interest is not defeated by subsequent transfer that takes place. A subsequent transfer of property terminates the license. Now, further is the licensee's rights. If there are any persons who is creating issues, encroachers and all, the licensee cannot take action. It is the licensor who is the owner who will take action. Contrary, in case of a lessee, he can take action in his own name. Difference between co-owners and joint owners. And co-owners are ones who are, though not specifically mentioned about what is the share. In that, when people are co-owners, if one person expires, then his share would go to his heirs, either by intestacy or by will, and those people become co-owners of the property. In case of joint owners, if one of the joint owner expires, his share passes on to the other joint owner. That's the difference between a co-owner and a joint owner. Now, other question which arose was what is properly declining and improperly declining. Now, section that is relating to sale, this question was, and naturally, after search or after inquiry, if a party, the buyer purchaser comes to a conclusion that there is a difficulty in the title or the property could not be transferred to him as was expressed to him, then if he declines that, that would be properly declining it. But suppose the purchaser comes to a conclusion that the property prices have suddenly fallen down and therefore refuses to complete the sale, that would be improperly declining to complete the sale. Now, the other question is the developer required to tell the landowner the FSI benefits of the land? Now, in a development agreement, again, ultimately the property is conveyed to a cooperative society or to a condominium, and therefore if there are certain benefits which materially impact the value of the property, then in my view the developer is duty bound to let the landowner know the exact FSI benefits which would materially impact the value of his land. This is again an aspect which runs with the contract, and therefore whatever impacts the value of the land, to prevent any allegation of fraud also, it is necessary to, these are again which are to be expressly brought to the attention of the owner. Now there was one question which if you can have the person who has asked this question to specifically bring it to my attention, I will answer that because I think this is case specific. The question asked was, can an unmarried granddaughter, son's daughter staying born and brought up in same Mumbai property object to transfer of property to married daughter, father's sister staying in US? The granddaughter has no property in her name, and the married daughter in US has properties in US as well as another property in Mumbai. Now I don't know whether how this transfer of property is to be brought about. Is it by inheritance? And if it is by inheritance, is it by will or is it intestacy? And whether the son is living, this unmarried granddaughter's father, is he still living? All those questions would arise, because how would otherwise, except by a right in the title of the property, somebody can object for transfer taking place. Possession is other aspect. Vacating of possession, whether person would be ejected or not, is another aspect. But as far as transfer is concerned, only a person whose rights are impacted or whose rights are being transferred without proper compensation or proper consideration to that person, only that person can object to a transfer taking place. So this is the other thing which requires case specific query which is made. Certain more facts are required, certain more details are required, and I would definitely gratuitously answer that. What are statutory act governing agricultural leases? Now, these are, if I'm not mistaken, the Bombay Tenancy and Agricultural Holdings Act uh, that that governs agricultural leases. And question about whether disputes relating to that would be depending upon whether there would be any specific jurisdiction assigned to a particular court who are only entitled to hear the particular disputes. If that would be the case, then maybe arbitration would not lie. But it has now been brought to my attention that there is a recent judgment which is different or contrary to what the earlier position was, that disputes between lessor and lessee are not arbitrable, and this is small causes court in Mumbai, which has exclusive jurisdiction, can only hear those disputes. But there seems to be a recent judgment which is taking a different view. So taking all that into consideration, the jurisdiction aspect will have to be looked into and an opinion be given. See, if there is a question whether the lessor, who under section 108 is bound to provide any, all information relating to material defect. The question is whether the lessor can evict the lessee if given, if there is a material defect. I think that that right, in my opinion, would not be available to the lessor to take advantage of his own wrong. But if there is a material defect, it would be the lessee who can take a view as to what he wants to do. And if he's in a position to enjoy, then he may opt to enjoy the same because he has that right under 108 itself. What he wants to do, it would be void at his option. And if there is a material defect, or if there is any third party who has a much better title than the lessor, or who has the title than the lessor, then that is that person who will evict the lessee if he is wrongly given possession of. So I don't think the material defect to about which the lessor would be aware and still he has gone ahead and played a fraud on the lessee would have a right to evict the lessor on lessee on that ground. Thank you for giving me this opportunity.